Ladies and gentlemen, today's session on point of international law. I would like to focus on point of several topics, and in tackling those topics, I would like to prove that explaining several case laws or the brief of the case laws and those case laws are very much significant in the world. Okay. The first topic is the recognition of governments. Costa Rica versus United Kingdom, 1923. This is the case law. And well known to you, Tinoco arbitrations. This is the case law, and simply, this is known to you. And what is the facts of the fact of the case? You know, this in 1917. Federico Tinoco came to the fore in Costa Rica through a coup d'etat and established a de facto government. Although the Tinoco government exercised effective control over the territory and administration of Costa Rica, it was not formally recognized by several foreign states, including the United Kingdom. During this rule, the Tinoco government entered into various contracts and financial transactions with the British nationals, including loans and concessions. In 1919, the Tinoco government collapsed and a new constitutional government took over. The successor government of Costa Rica refused to honor the obligation created by the Tinoco's regime, arguing that since the Tinoco government was unconstitutional and unrecognized, its acts were legally void under international law. The dispute was referred to arbitration, with former U.S. Chief Justice William Howard Taft acting as arbitrator. This is the significant case law in the world, Mr. Kobe. Just imagine that. So what is the recognition of government? Now, the issue may arise in that very case law is that whether acts of unrecognized and unconstitutional government can create a binding international obligation for the state, whether yes or not. The decision-making power of the court, yes, the acts were binding on Costa Rica. Now, why? What is the reasoning behind this? The arbiter held that international law looks at effective control and actual exercise of authority, not merely formal recognition, since the Tinoco government functions as the government of Costa Rica. In fact, its lawful acts could not be ignored by successive governments. This is the case law to prove that the recognition of government, and this is very much important, the Costa Rica versus United Kingdom, 1923. Now, another topic is territorial sovereignty. Well, Mr. Kobe, just imagine that, not to memorize. Island of Palmas case law, the Netherlands versus United States. This is the glowing example in the world, 1928. So what are the facts? What are the facts of that very case? The dispute concerns sovereignty over the island of Palmas. This is the Miangas located between the Philippines and Indonesia. The United States claims title to the island to Spain based on Spain's discovery of the island in the 16th century, and the subsequent Treaty of Paris 1898, by which Spain ceded the Philippines to the USA. The Netherlands, however, argued that although Spain may have discovered the island, it never exercised continuous authority over it. The Netherlands claimed sovereignty based on long-standing and peaceful display of state authority through the Dutch East Indies administration, including legislation of local affairs and acknowledgement by local rulers. The dispute was submitted to the arbitration before Judge Max Haber. This is the issue matters in whether the discovery alone is sufficient to establish territorial sovereignty under international law, whether yes or not. This is the question. And decision of the sovereignty belongs to the Netherlands. And reasoning in this matter, the arbitrator held that the continuous and peaceful display of the state authority is superior to the mere discovery. Discovery without effective occupation doesn't create a valid title. So this is the case law. And now the law of treaties, Prince John's of Abu and the District of Cax, France versus Switzerland. 1932. This is the case law, and the fact is the other treaties concluded in the 19th century, certain areas near the Franco-Swiss period were designated as a free chance exempt of customs duties. France later attempted to modify these arrangements unilaterally, arguing that economic and political changes justified the alteration. This is the alteration of treaty obligations. So Switzerland objected and brought the dispute before the Parliament Court of International Justice and claimed that France was bound by its treaty commitments. Not the issue whether a state may unilaterally modify or terminate treaty obligation, whether yes or not. The decision France couldn't but exactly laterally change the treaty. So what is the reason behind this? In this case law, that the reason the court reaffirmed that the principle of pacta sunt servanda, warning that treaties are binding and must be performed in good faith. So in this matter, the pacta sunt servanda will be discussed in that very case law that should be kept in your CPU. Now the state responsibility number 4. So the Georgios factory case law, Germany versus Poland, 1928. This is the case law. And what are the facts in that very case law? After World War I, after Silesia were transferred from Germany to Poland ceased but exacted nitrate factory wanted by a German company, allegedly in violation of international agreement for testing foreign property. Germany fought a claim before the PCU, arguing that the Poland's act was internationally wrongful. The main issue that's only whether the seizure was illegal, but only whether remedy in international law requires for such violations. The issue may as what are the legal consequences of the international wrongful act. And the decision point was required to make full reparation. This is the case law, and the reason the court would exact the famously held that the reparation must as possible out of the consequence of the illegal act through the restitution and compensation. Have you got that, Mr. Kirby? Yes, okay. Just not to write. Just that should be kept in your CPU. Now the topic number 5 is the diplomatic protection that the non-public case law and Liechtenstein versus Guatemala in 1955. So this is the fact. Mr. Nottebohm was a German national who had lived in Guatemala for many years. During World War II, he acquired what is the Liechtenstein's, that's the Liechtenstein's nationality through a fast-track nationalization process, primarily to avoid the consequence of being credited as an enemy alliance. Guatemala later seized his property and expelled him. Liechtenstein already came before the International Court of Justice seeking diplomatic protection on his behalf. Is whether nationality acquired with a genuine link is sufficient for diplomatic protection. The case law decision in Liechtenstein's claim was rejected. And the reason behind this, Mr. Kirby, the court held that the nationality must reflect a genuine connection between the individual and the state claiming diplomatic protection. And number 6, The use of and non-intervention, the Nicaragua versus United States in 1986, this is the case law, and facts of the very case law. The United States supported the counter-rebels who were fighting against the Nicaragua government, support including funding training, supplying weapons, and mining Nicaragua harbors. And Nicaragua filed a case before the ICJ and alleging violation of sovereignty and international law. So what the use of force and non-intervention, that should be clear. And the USA argued self-defense and questioned the court's jurisdiction is whether it indirect military support considered unlawful use of force or not. This is the issue. And this is, yes, the USA violated the international law. And reasoning in this regard, so that the reasoning, the court held that the principle of non-intervention and prohibition of force, breast and self-defense was not justified. And several case law in this matter, just imagine that, Mr. Covey. You have to keep this idea. That's the Nicaragua versus United States 1968 on point of that's the non-intervention and prohibition of force based. So the USA is liable for that, and this was not justified. Now is the topic number 7 is self-defense. This is the Castro, Caroline Castro, 1837 maybe. So in this case, the facts of the case of tuning liberal is Canada, British force goes into U.S. territory and destroys the American steamboat, and Caroline with less lasting rebels. The incidents led to diplomatic protest between the USA and UK. Issue is what are the conditions for the lawful self-defense, and decision self-defense is permitted only in extreme necessity. So this is the Buddhist doctrine of necessity. And reasoning this necessity must be instant, overwhelming, living, but exactly no choice of means and no moment for deliberation, and the response must be proportionate. So number 8 is international environmental law. The prayer is case US versus Canada 1941. This is the case law. And what exactly number 8 is self-determination. And not only that, the number 2 and international environmental law. Well, smaller case US versus Canada 1941. The fact is smaller, smelter plant in Canada emitted toxic fumes that caused the mood into the United States, causing serious damage to crops and forests in Washington State. The US claimed compensation for environmental harm. And in this case, the issue is whether a state is responsible for what exactly the transboundary environmental damage, whether yes or not. The decision Canada was held responsible. Reasoning in this international law prohibits states from using their territory in a manner that causes serious injury to another state. And number 9, the list, what exactly the last but not least, the self-determination China Advisory Opinion 1975. And so the Spanto Advisory Opinion for the ICJ regarding the legal state of Western Sahara pure colonization and whether Morocco and Mauritania had sovereignty claims over here. And whether this issue may try to claims over it, the right of self-determination. And decision maker that they don't. And reason the code impasses that the primacy of the right of the people to self-determination and the sea. Love the sea is the case law and today's tomorrow. This is the case law and several case law and Bangladesh versus Myanmar and Bangladesh versus India. Those are the case law on point of the love the sea. In earlier cases, I have focused on this matter and I will discuss and later discuss on matter from the side of the international law, the public international law, and not only the law of the what exactly the private international law and public international law and law of the sea and human rights law, which is several data even the articles in the UDA 1948 and not only that the CEDAW and all the what exactly the international charters and international today's memo, and those discussed media will be earlier focused by me. And this is last night, today's memo. Bye-bye. Do you see next? That the next topic will be discussed by me from the side of Lord Actor to you and the sister concept of Ainshok Academy in the world. That's the best law academy in the world. Today's tomorrow. Bye-bye.